Well, good to have you with us here on the Thursday edition of the South African Morning. Let's go back to our top story where Parliament's bid to adopt rules for the removal of the head of Chapter 9 institutions has received a blow. You want some context? Good, we'll need it. Yesterday, the Western Cape High Court found that certain impeachment rules are unconstitutional, specifically not allowing Public Protector Mkhwebane legal representation during part of the impeachment process, and allowing a judge to be a member of an independent panel considering the motion to remove her. So what does that all mean? It's quite heavy for this time of the morning, but let's now speak to ANC MP joining us this morning to unpack this. It is Mr. Richard Dyantyi joining us. He's the chairperson of the inquiry into Mkhwebane's fitness to hold office. Richard, good morning to you. I appreciate your time, and this is a very complicated, legally driven, parliamentary process-driven discussion. I'm going to try and keep it as simple as we can. Off the back of what we saw yesterday, what does that mean for you this morning? How does this change things?
Thank you. Good morning, Gareth, and your eNCA followers. The Public Protector had 12 points, call them 12 prayers, that she sought relief from the court. And out of those 12, the court said she only succeeds in 2, the one about legal representation and us removing the reference to a judge. What this means is that yesterday we met as a committee and we started developing our work plan, our roadmap, so to speak, as to what rules are we going to use to follow this. So if yesterday, Gareth, we had 12 milestones out of that work plan, what this means is that we might need to add another milestone that is attending to this, because the court is saying you've got to relook and amend the legal representation, which will be much easier because the legal representation participation will only be required when we start the hearing.
Okay.
We're in a pre-hearing phase as we speak. And in terms of yesterday's program that we developed, that's some weeks to come before we get to that point. And so effectively it means there are certain defects that the court has identified that we need to remedy.
Okay.
And so, as you would have heard the speaker saying, going forward, we are going to sought legal advice so that we have a tight process that is not challengeable going forward.
So essentially, what my reading of this is, and it's a good thing I'm speaking to experts like you on this, this is more about an admin issue. It's about the process that's being followed when it comes to the fight for the inquiry into the fitness for the Public Protector to hold office. Does this in any way change your view? Does it change Parliament's view on the PP's fitness to hold office?
It doesn't. Remember, the court did not get into the merits of the inquiry, the contents of the inquiry. It did not get into the evidence or the prima facie that was presented out of the panel, nor did it even say that panel report is thrown out of the window. That remains intact. But this process, this inquiry, both the process and the outcome of it are equally important for us to attend to. So this therefore means that we've got to now be much more vigilant in terms of how this process, how we apply these golden rules of rationality, of fairness, of audi throughout and in every step of the process, in every step of each of those kind of milestones in this 6 months period that we identified for ourselves.
So you just mentioned a 6-month period identified for yourselves. Timeline-wise, is that what we're working towards, 6 months before some kind of resolution is made on the fitness to hold office? Or what does our timeline look like as far as Parliament is concerned and, of course, the Public Protector to come back and counter any arguments? My last question to you, Richard.
The end point of our inquiry is 6 months, which take us to January. So we're saying anything between 3 to 6 months, we want to work within that time frame. I'm hoping that we'll be able to do it before the 6 months, but we have given ourselves 6 months to conclude the work and present findings and reasons for those findings to the National Assembly, even with this added requirement or milestone based on the court judgment of yesterday.
Okay, well, I appreciate your time. It's a complicated issue, but I think you've explained it brilliantly for us this morning for laymen. When I say laymen, I mean me, eNCA Member of Parliament, Mr. Richard Dyantyi joining us here on eNCA. It is such a complicated issue, but essentially the court ruling that 2 of the 12 issues that the Public Protector had brought to court do need to be put into place in order to continue fairly for both parties in this inquiry into her fitness to hold office. That's the sum of that story.